SJC-13077 in the matter of Paul M. Sushchyk.
Okay. Attorney Neff.
Good morning, Chief Justice Budd and the Honorable Justices of the Supreme Judicial Court. May it please the Court, my name is Howard Neff, and I am representing the Commission on Judicial Conduct in this matter. The matter before you today is one of extremely serious judicial misconduct. The hearing officer in this matter not only found strong, clear and convincing evidence that Judge Paul Sushchyk sexually assaulted Miss Emily Dines on the night in question, but she also took the exceptional and extraordinary step of also finding that Judge Sushchyk misled Chief Justice Casey during his investigation of Miss Dinah's complaint, and then offered testimony during the formal hearing of this matter under oath that was not truthful. In her report, she stated, Judge Sushchyk generated a statement that he knew to be false, in which he invented out of whole cloth a version of events which Miss Dinah's very clear perception of what happened to her was to be dismissed as misimpression or exaggeration. He admitted under
Counsel?
oath. Yes.
So the argument on the other side is that there just isn't clear and convincing evidence of the assault that was alleged here. What is your response to that?
Well, my response to that is that the hearing officer, who, as you know, is a former Superior Court judge with 24 years of experience, making findings of fact.
Right. I understand that we defer to her credibility findings. So what is the clear and convincing evidence of the sexual assault?
Okay. Well, in this particular matter, Ms. Dines was subjected to rigorous cross-examination by Mr. Angelini, as Judge Josephson noted in her report, regarding what she did.
Right, and I guess the problem is that under that cross-examination, she said, I don't know if there were other people behind me. I don't know if he was the only person. And so I just need a response to the argument that Mr. Angelini makes with regarding to whether or not there is clear and convincing evidence of the sexual assault.
Okay. Well, to that, I would answer, Chief Justice Budd, that at the end of...
Sorry, it's Justice Wendland. I'm sorry. There must be something that goes on with my voice. Thank you for the elevation.
Apologies.
No, that's okay.
To answer that question, I would say that the totality of Ms. Dinah's testimony, as found by as found by Judge Josephson, by clear and convincing evidence, was that she saw Judge Sushchyk approach the table, go around a brick pillar, appear on the right side of her shoulder, right behind her, disappear behind her. At exactly that moment, felt someone grab her left buttock, and then immediately thereafter, Judge Sushchyk appeared there speaking to Ms. Patsos. So what you have in this case is...
So you're saying that that's enough to infer that he did the sexual assault?
Well, I would agree. What you have here is a case of direct and circumstantial evidence. You have testimony from which a reasonable inference can be drawn that it was Judge Sushchyk who was indeed behind Ms. Dines and the only person directly behind Ms. Dines at the time that her buttock was assaulted. And if you're looking for any corroboration of that, Judge Sushchyk's own May 20th, 2019 statement to Chief Justice Casey admits that he came into momentary contact of a lower portion of Ms. Dinah's body on the night in question.
All right, and what if I think that the evidence of what do we make of the evidence of the whiskey flask? Is that relevant? Is that, how do we weigh that?
Well, both the in this matter, both the hearing officer and the commission, well, the hearing officer made findings that did not amount to misconduct. The commission in its report adopted the hearing officer's findings that did not amount to misconduct.
So this case is really about the assault
Well,
and the failure, the testimony, the written statement.
the misconduct is the sexual assault and the misleading and the lying. I would suggest that the relevance of the flask is, as you may recall, Chief Justice Casey saw Judge Sushchyk earlier in the evening on the same day that this assault occurred. Judge Sushchyk appeared tired, not as energetic as Chief Justice Casey was used to, had red eyes. Judge Sushchyk subsequently showed up at this table full of probate and family court employees. For whatever reason, felt it was appropriate to display in whatever manner he displayed, whether it was removing it a little or a lot from his pocket, that he was carrying around his own personal flask of hard liquor. I'd suggest that goes to his state of mind, where he was at, his judgment, and could be an explanation for why he behaved the way he did toward Ms. Dinah's.
And how do we weigh that in terms of the punishment that's being recommended?
Well, in this case, I would say the court has a precedent for how it deals with cases of sexual misconduct and sexual harassment by judges, and that's the Estes matter, where this court imposed the strongest possible constitutional sanction available. Here, Judge Sushchyk, to borrow from Judge Josephson's report and Ms. Dinah's own statement during the 11E hearing in this matter, Judge Sushchyk's conduct did not cross a murky line. His conduct was so far over the line.
I mean, the line was not murky, right?
Line was not murky.
Okay.
His conduct was so far over the line that I would suggest it renders him permanently incapable of commanding the respect and authority necessary to resume his judicial office.
Counsel, Attorney Neff, what weight do you give the fact that the judge found that the hearing officer found that the judge lied or made misrepresentations in his first response?
I'm sorry, just a second.
What weight is it in this analysis? How much weight should we give the fact that the judge affirmatively lied to the during the investigation or to the before the hearing, and then changed the story at the hearing?
Well, in the commission's report to this court, the misleading of Chief Justice Casey and even the false testimony under oath are characterized as aggravating factors for the court to consider, because those are, particularly given the way in which those fact patterns evolved, could not really possibly have been part of the formal charges. Having said that, issues of a judge failing to be forthright and provide honest information to a Chief Justice in an investigation, and issues of a judge who, under oath, gave testimony that was not truthful are serious enough to merit the same type of sanction, I'd suggest, we're proposing for the sexual assault against Ms.
Do you think the sanction request would be the same if you didn't have the misleading statement?
Absolutely. I think either the sexual assault against Ms. Dinah's renders him unfit to remain on the bench, or his decision to mislead Chief Justice Casey and lie under oath. Either of those
In every case,
actions amount to reasons that he can't serve as a judge.
I'm confused by that. So you're saying that in every case before the commission, either one of those would be enough for the ultimate sanction, which is removal from office. That you always do that. That this level of misconduct, meaning a single action like that, always results in that. Is that right? I'm curious, because unlike the hearing officer, you have sort of a broad understanding of what the commission has done historically.
Yes.
In all their, and you have gradations of response for misconduct. So either one of those things, as opposed to the combination, is enough. But under your historic, the way you've interpreted the commission's disciplinary, because no one knows it better than you, right? You've been there how many years?
Over 15 now.
So I just want to make sure of that, because it seems to me the combination is compelling, particularly if we have deliberate lying. But you have always imposed the ultimate sanction for this kind of single action like this.
In my experience, we have, yes.
Can I follow up with you on that, Attorney Neff? Because one of the other cases that's cited, I believe, in one of your briefs talks about the OUI. And I'm not necessarily saying that what we're talking about here isn't serious, but I know prior to this that you were in the district attorney's office, and you know that whatever this charge would be a misdemeanor, right? And misdemeanor charges prior to this for other judges have not resulted in the ultimate sanction that you're now requesting of the court. Again, I'm not minimizing the specific found conduct here, but I'm saying that at the end of the day, it would be a misdemeanor charge, and there have been other judges that have pled guilty to misdemeanor charges that are still practicing, that are still presiding.
Right. Well, I would agree with you that has indeed been the case. However, I would disagree that those cases bear sufficient resemblance to the very serious misconduct at issue in this particular complaint before the court for the commission's decisions in those matters to be relevant in any decision this court makes. Mm-hmm. It also, speaking
Is that
generally,
because it was a clear line, it was at a court event? I mean, how do you come to the conclusion to Justice George's question?
And can you tell me which part of?
I'm sorry?
Can you repeat the question?
Yes. So you said that those cases, the OUI misdemeanor cases, are not comparable, period, full stop. Can you tell me why? Is it because this was a clear line that was crossed at a court event? What is it that makes this different than the OUI?
Well, I think even a casual review of the statistics of how criminal matters are resolved throughout the various district and municipal courts of this Commonwealth would show you that when a court is addressing at least a first offense drunk driving case, the sentence imposed and the way that it is dealt with this seriously, but it is not dealt with nearly as harshly as, for instance, a case brought before the court alleging indecent assault and battery on a person over 14.
Right. So you're explaining the sort of the details, but like, is it because there's a victim? It's at a court event. It's a clear line. What is the difference?
Yeah, well, it's a good question. I mean, if there was a variation of the fact pattern, and this is really just a hypo, and there's no precedential value to rely on here, if a judge's OUI case, and I have to be careful because, as I mentioned in the brief, all of our agreed dispositions referenced in Mr. Angelini's brief have terms that require that we not publicly comment on their terms. So I want to be general.
I think we want you to talk conceptually, not by name, but what kinds of offenses are the ones, I mean, because again, we're trying to evaluate the continuum of punishment that you have the capacity to do. So we're, without talking about specific cases so much as specific criminal activity, as Justice Wendland just pointed out, whether it's engaged in at work or out of work, whether it involves other court employees. I mean, those are the types of, it doesn't sound like it matters to you.
Well, it always matters, but with every human experience and mistake, there are always different factors and facts and issues in play that the court, excuse me, not the court, but the commission has to look at in connection with trying to come up with the right result. And
So it isn't, as you said earlier, the single action, it's the totality. It's, or is it?
I'm not how to answer that other than to say that I would respectfully suggest that a sitting judge of the Probate and Family Court who's at a work-related conference, who sexually assaults an employee of the Probate and Family Court by grabbing her left buttock, is serious enough and so far over the line that there's no need for the commission to muse or consider or wrestle with whether or not the ultimate sanction is appropriate. And as I said
Okay,
in my brief,
I'd like to switch you, because I know we're over already, to,
I see that.
to me, it was very critical that the judge found that, meaning the hearing officer found that the judge walked back his statement and admitted he lied. Could you walk me through what the judge, because Mr. Angelini's brief doesn't read that way. So do you have the transcript in front of me? Do you know where, I haven't read the whole transcript yet. What does he say that basically admits that he made this statement up? And is it ambiguous or is it clear cut?
He does make a statement which I would characterize as not credible or believable, which is that facing this serious allegation of sexual misconduct with 10 days to reflect on what he was going to reduce to paper after first being confronted with this allegation of sexual misconduct. He reduced to paper a factual scenario in
No,
which
I'm asking a different question.
Okay.
At the hearing, Judge Josephson says she finds that he basically admitted that he lied to Chief Justice Casey. And I'm just trying to make sure how, I haven't read the statement yet. Do you have it in front of you, that part of it, or the transcript? I'm going to ask the same question to Mr. Angelini, because to me, that may be the most important factor here, that he's admitted to lying. Do you have the, I just would like to pin that down so that I understand the basis of that.
I don't have the exact statement in front of me at this point, but in that statement, his admission, which I may not get correct word for word, was that he arrived at the table with Ms. Patsos and others, offered to buy them drinks. At a certain point after doing so, left to go to the men's room, and in his written statement, said to Chief Justice Casey, attributing my long day and my recent hip surgery and another medical issue and the alcohol consumed, I may have inadvertently come into contact with a lower portion of Ms. Sushchyk's body.
Yeah, but from my understanding, the judge says that he walks back that statement and says, I never made any contact with her body, I'm sure of it. and I just haven't read the transcript yet.
Attorney Neff, wasn't that the part where I believe Judge Josephson said, or there was some comment that the judge was concerned that Ms. Dinez was going to be believed and therefore as a prophylactic made up this story because he thought that she was going to be believed in the first instance, something along those lines?
I would answer that Judge Sushchyk's problem was best described by Judge Josephson in her findings after she had a chance to hear all the testimony, including the testimony elicited by Mr. Angelini, where she found Judge Sushchyk generated a statement, meaning that May 20th statement, he knew to be false, which he invented out of whole cloth a version of events in which Ms. Dine's very clear perception of what happened to her person was to be dismissed as misimpression or an exaggeration. He admitted under oath in truth that what he wrote happened, simply had not, to answer the other question. Such misdirection during the investigation not only evinces consciousness of guilt, but is wholly inconsistent with the oath of office and ethical conduct required of a judge.
Everybody else set?
Well, the last thing I'd say is if you really are at a point where you're thinking about, well, how do you weigh Ms. Dinah's statements, Judge Sushchyk's statements, the defense as Mr. Angelini has presented on behalf of Judge Sushchyk, I would just say this. In her report, Judge Josephson saw through Judge Sushchyk's inconsistent and incredible explanations for what happened that day and wrote, Judge Sushchyk's lack of candor at the inception of this matter undermines his credibility at hearing. His initial response suggests he did what he was accused of doing and sought to minimize his culpability for it. I do not find Judge Sushchyk's testimonial denials of intentional contact consistent and credible with the complaint that she was grabbed by Judge Sushchyk is only more believable than his reworked denials. It is bolstered by them. I find Judge Sushchyk's testimony at hearing is a further instance of his failure to be truthful in this matter.
Okay, Attorney Neff, we can read that, so we'll thank you for your argument. I'm going to ask Attorney Angelini to step up.
Good morning, Your Honors. May I proceed?
Yes.
My name is Michael Angelini. I represent Judge Paul Sushchyk. Let me do what I did not intend to do, and to address this issue which my brother has characterized as lying. First of all, let me say that there is a procedure before the Commission on Judicial Conduct which requires that if a judge is alleged to have engaged in misconduct, formal charges may be brought against him. There is no formal charge here that he lied to anybody.
Counsel, let me just say, I think I characterized it that way, and I don't think Attorney Neff did. But you can make this more clear for me. To me, it seems pretty straightforward.
Yes.
That there is a testimony and a finding that your client engaged in this conduct, and that there were misrepresentations made about it. And I grant you there are no formal charges on that. So how is this more complicated?
How is this more complicated than what, Your Honor?
Than what he did? How is it more complicated? Judges shouldn't do this.
The basic issue in this case is what, if anything, happened? This case, let me get to his statement in a moment. This case is built not on facts, but on belief.
Isn't that limited, though? Because I'm confused by what is, sorry, I apologize. I'm confused by, because if the findings of fact she makes find that your client is not telling the truth, she makes those expressly, and she relies on them heavily for the remedy, which is retirement from office. So we have to deal with both the act and the truthfulness issue, or we're not, or maybe tell me why we're not supposed to do that.
You could do that. I would say to you, though, that there is a procedure. If they want to bring formal charges against Judge Sushchyk for this statement, which I'll explain in a moment. I've tried to do that in my brief. Let them do it. We will defend it.
But that's not the point.
But the point is-
Sir?
Yes, excuse me, Your Honor.
Yep. So that's not the point here. We're not looking at whether or not he lied. The findings are that he lied.
Yes.
Okay, so we now have to accept those findings unless they're clearly erroneous.
And they are. And let me tell you why they are.
Okay, let's do that.
Let me tell you why they are. Because when Judge Sushchyk was presented, Judge Sushchyk had met this woman once in his life for what she described as a very short time. They were not known to each other beyond that. He was presented by Judge Casey with a statement from her, which is it's in Volume 1, page 95, and in Volume 1, page 152. The statement said, "I believe the person who grabbed me was Paul Sushchyk because, 1, he had recently come over to the table where I was seated. He had recently come over to the table where I was seated. And 2, and we'll get to this later, he was the only person behind me at the time of the grab." Judge Sushchyk was presented with that statement by Judge Casey. Judge Casey testified to this at the hearing, and he said, "You should prepare a statement in response." Judge Sushchyk, as he said, you can read his testimony, went off and deliberated about this. He denied anything happened. He did not recall any intentional contact with her or anybody else. But he read and deliberated about that statement, and he remembered that sometime that evening, as he testified to, he got up and went to the bathroom and came back from the bathroom and went through this crowd of people behind that chair and had inadvertent contact with someone sitting in that chair, whom he assumed was Ms. Dinas. What he later learned was that Ms. Dinas claimed that this did not occur when Judge Sushchyk came to the table. That this in fact occurred not later in the evening, but when he first came to the table. And that when he went to the bathroom and came back, if he inadvertently touched somebody, it was definitely not Ms. Dinas, because according to her testimony, she left 10 minutes after finishing her beer and after he arrived. So he does not say, as my brother has said, and does not say, "I lied, I misstated." We're talking about two very different circumstances, and the one which is covered by his statement does not involve Ms. Dinas, and he never, never, never has acknowledged any intentional contact with anybody.
Does this statement say that it was Ms. Dinas?
No, he assumed it was Ms. Dinas. Well, he may, but it
What
could
does the
not have
state-
been,
who
because
does
she had
it-
left by the time he'd gone to the bathroom.
Excuse me, counsel. Who does the statement say he touched?
Somebody sitting in that chair.
Okay.
Somebody sitting in that chair. That's the beginning and end of this with respect to the lying. The basic issue which gets us here, the charge by the commission, is simply based not on any fact, but on a belief. A belief by Ms. Dinas that this was Judge Sushchyk for 2 reasons. 1, he had recently come to the table, which we know he had not, according to her later testimony. Her later testimony was he was arriving at the table. And then she says, he was the only person directly behind me at the time of the grab. She has no idea who was behind her.
Well, counsel, can I interrupt you on this one point?
Of course,
Because
Your Honor.
it relates to another argument that you make in your brief that I'd like you to touch upon.
Yes.
So in this case, Judge Josephson has a hearing where she's both she's the finder of fact, okay? And under the clear and convincing standard, you're advocating that it's not enough for the finder of fact just to believe a witness, irrespective of whether there's any corroboration. And that's not been the case, right? Where if you've got a he said, she said case, the finder of fact can choose to believe one and not the other without any other corroboration. But you're asking the court to now take a position where we require corroboration, but let me just be pointed at one thing.
Yes, Your Honor.
Assume that we don't follow you, that we leave the law as it is, that the credibility assessment can be, if you think it's a jump ball and it happens to go against you, that's enough.
We're not talking about a jump ball. A
Why not?
finder of fact is required to find facts based on evidence, not
Sure.
based on belief.
Well, perhaps, but as Attorney Neff laid out, there were inferential pieces in the circumstantial case that led the finder to find that this was Judge Sushchyk.
There are no inferential pieces which deserve any attention. The role of this court is to correct mistakes made by the lower court. And in order for there to be a basis for finding facts, for determining the credibility of witness, there need to be some facts. Mr. Neff said it. She claims she saw Judge Sushchyk walking in her direction. She claims she has no idea who was behind her. She admitted it, I put this in my brief, that anyone of the crowd behind her, and she admitted there was a crowd of people there and that behind her was a passageway.
But isn't there there's a duration of the grab as well? It's not, right? She says, is there a duration of the grab? Like it's a 15?
This occurred between 5, 10, or 15 seconds.
Okay, but
Two
that's,
independent witnesses
so hold on,
that-
just give me a second. So if she's, again, the judge finds she's credible, so that somebody grabbed her for 5 to 15 seconds, right?
Right.
1,000, 2 1,000, 3 1,000. That's not you can't just walk by somebody and grab them for 5 to 15 seconds, can you? It's hard. You have to be behind them, right, for that long a period of time?
Yes, of course.
Okay, so I'm taking the facts that the judge could find. The judge is also, Judge Sushchyk is standing next to her during that period of time, correct?
No.
Hold on, again, I have pictures.
Here's the evidence, Judge, if I can just summarize.
I know, but I want.
Giving her the benefit of every doubt. She says, I saw Judge Sushchyk as he was walking towards the area behind me.
Right.
She says, I have no idea who was behind me.
Mm-hmm.
She says, I was grabbed by somebody in her latest iteration, someone slid his hand under my left buttocks, lifted it, and grabbed and squeezed it between 5 and 15 seconds.
Right.
She says, I then later saw Judge Sushchyk talking to Ms. Patsos, who was immediately to my left. She says, under oath, I have no idea how long it took me to turn and look to my left. She says, I have no idea how long he was speaking to Ms. Patsos when I turned to my left. She says, I have no idea who was behind me at the time. Two independent witnesses, lawyers in the trial court, in this court, testified under oath. I saw him walking. One of them is Patsos, who was directly to her left. I saw him walking behind her. He never stopped. Another one, Jocelyn Welsh, who was talking with Ms. Dinas across the table.
Hold on a second. Could I? Go ahead.
Excuse me for raising my voice. I apologize.
Counsel, can I so you're focused on some of the evidence. Can I just ask you, I'm going to read you some of the evidence
Yes.
and then ask you why that doesn't lead to the conclusion, a supportable conclusion by clear and convincing evidence that in fact it was your client that grabbed her. Ms. Dinez says,
Could you keep your voice up, Your Honor? I'm sorry.
Ms. Dinez says, as he passed behind me, I felt him slide his hand under my left buttocks and grab me. And there was no one else directly behind me at that time that I know of, no. I paused, and then I turned around. Did you say anything to him? No. I saw your client behind me over my left shoulder, and I saw Evelyn standing next to him. How long did the grab actually last? Geez, I don't know. 5, 10, 15 seconds, something along those lines. Why couldn't somebody take that evidence, that testimony, and conclude by clear and convincing evidence that that in fact was your client who grabbed her?
Because she does not know what she testified to. She did it under cross-examination, and I've included it. She does not know that he stopped behind her. She does not know it was him who grabbed her. She does not know who grabbed her, despite what she said in that statement. And that is the crux of this matter. This is an allegation based on belief. And when we begin incriminating people based upon belief rather than on fact, it'll be the dawn of a new and bad day. That is why that deserves no attention. She testified under oath.
You're saying we can't believe her direct testimony. We must instead believe her cross-examination testimony unless there's independent corroboration.
I'm saying if you're going to give credit to a witness, you need to listen to all a witness says. You can't give credit to what the witness says and disregard inconsistent statements.
But counsel, let me stop you there. Because even in, let's just take in the criminal context, we know that the judges instruct the jurors when they go to the instruction on the credibility of witnesses that they can believe all of what a witness says, some of what a witness says, or none of what a witness says. So why doesn't Judge Josephson have the same right to say, I can pick which part of the testimony I choose to credit and not credit all the parts of the testimony? We tell jurors that every day.
Here's why. You can credit testimony of a witness who sees something, who hears something, but you cannot credit what a witness believes.
What about when a witness feels something, counsel? What about when a witness feels something?
When a witness what?
When they feel something, can you credit that? That they felt it?
Well, I suppose you need some evidence that a witness steals something. You need facts. You can't have just belief. I
can't believe that I'm feeling something?
I'm sorry.
I can't believe I feel something?
Well, by the way, there's no doubt.
Question, I apologize.
That's all right.
I'm confused, though. Don't you agree there's enough evidence that someone groped her? The question, your fight is over who it is, right?
Yeah, I happen to think it's doubtful. I think there's a good chance that nobody groped her, but listen to her. But put that aside. There is no evidence that he groped her. There is none. There is none.
Can we just slow down for a moment? What you're saying is, on cross-examination, she has no personal knowledge as to the individual who was grabbing her. That's your position of what she said on cross-examination. When you, just let me finish.
Yes, correct.
I know
correct.
there's a lot at stake, but just slow down for a minute. What just Wendland read to you from the direct
Yes.
isn't there clearly an inference, although she doesn't actually know who grabbed her, when you take everything that she testified to on direct, that there is an inference available in the light most favorable and taking into account the deference to the hearing officer, isn't there an inference? Well, I saw him in this proximity to when I felt this for 5 to 15 seconds, and it's a reasonable inference that it's him because she has personal knowledge that she felt something, and she has personal knowledge of the time between when she felt it and she first saw him. Why isn't that a reasonable inference? Not inevitable, reasonable.
Because it is not a reasonable inference if I walk from where I am to where Mr. Neff is, that I did something while I was on the way. It is not, if she had turned around and saw him, as anybody would, well, that's a fact. The judge can believe that. The inference is he was walking from here, I saw him later there, somebody groped me in the middle, and I infer that it was him. That is not a reasonable inference, particularly given her testimony that there was a crowd of people behind her, that this was a crowded place and a passageway, and she does not know who or how many were behind her. There could have been somebody in a Mickey Mouse uniform behind her. She doesn't know. And there is independent testimony by two people, employees of a trial court, who say he didn't stop. I think this is clearly erroneous by any rational standard, Your Honors. By any rational standard. And this whole business of a flask I won't pay attention to. If having a flask in your pocket and lifting it an inch out of your pocket, as even Ms. Dinas says, is an offense, I think you should change the canons of judicial conduct to make that clear. I suggest to you respectfully that if we leave this courtroom and you find that someone's belief, rather than what someone saw, what someone observed, someone's belief can lead to a judge being removed from judgeship, is something you should announce to the entire court, because all of you are at risk that someone will state a belief which is not grounded in fact and will result in your removal.
That's just not the analysis. The analysis is what she observed.
She
So
did
I'll
not
ta- hold
observe
on,
this
hold on.
occurring.
You'll understand the question better if you listen to it.
Yes, sir.
The issue is not what she believed. She testified to what she observed. What she believes, who it was, I understand what you're saying. She testified to what she observed. Now the question is, from what she observed, can you, not what she engages in conjecture on or speculation, what she observed, can you draw an inference that it was your client, particularly in conjunction with statements that at best for your client are not easily reconciled?
You could not draw an inference that it was more likely him than anyone else who may have done this to her. That is an inference I suggest to you respectfully cannot be drawn based on the facts you've set forth, Your Honor. May I just say a word about penalty? May I say a word?
Very quickly, you spent
Yes,
a lot
I'm
of
sorry.
time talking about whether it happened or not. We should probably look at that, but very briefly.
Thank you. I have pointed out to you the Commission on Judicial Conduct has said the case most comparable to this misdemeanor, if it occurred, is one involving Judge Estes. This is a case which has been overtried by the Commission on Judicial Conduct, I suggest respectfully, and that statement to suggest that Judge Estes, whom I don't know but about whose case I read, had sexual liaisons with a court employee in his chambers for a period of 7 or 8 months, spoke directly with this person about pending cases in his court, intervened in a personnel matter involving her, compare that to this case, and to disregard that judges of the Superior Court have been admitted to drunk driving on busy highways and continue to sit to this day without any penalty, without any sanction, without any cost, I suggest defies logic. So I have not been able to discuss that as much as I'd like, but I draw your attention to basic elements of fairness, and thank you very much.
Okay, thank you.
I appreciate your time.
Thank you, Counsel.